This is April 30th, 2015, and I'm Ted Borick, and I'm here with Burr Udall of the Udall firm. I was privileged to do an oral history of Burr that we finished in 2012 for the Law College Association of the University of Arizona College of Law. As a result of that, I learned that Burr's first office was now the State Bar office here at 270 North Church in Tucson. And so as part of a program for continuing legal education for the State Bar of Arizona and the Pima County Bar Association, we're going to talk to Burr and have it filmed here about some of the things that he experienced early on in his practice of law here in Tucson. And so, Burr, my first question to you, what is the significance of this building to your practice?
Well, this is where I started to practice law in 1954. I got out of law school in January. I came to work for the firm of McCarty and Chandler February 10, 1954, and their office was here. I got admitted March 27, 54. To this side of us was a law firm named Goldberg and Stevenson. We were here. On the top floor was the Farmers Insurance Claims Office, and the significance to me is this is where I learned how to start to practice law, and I hope I've learned how to by now.
What was it like when you, in the area around here, when you first came?
Well, over on this side was just small homes that had been vacated that were full of lawyers. Like I said, this side of the building was Goldberg and Stevenson. The courthouse is domed courthouse, which is a block and a half away, and there was nothing between us and it. You could see that courthouse plain as anything. All of the big high rises now didn't exist.
Okay, Burr, we're entering your office here. Tell me how things were when it was your office.
Well, we had a receptionist, right, they've redone everything, but right in this general area. And then we had one secretary there who answered the phone. Well, we had two secretaries that were in there. There was a wall here, or a door. Chandler's office was right in there.
Right where the kitchen now.
Right, where the kitchen is now. And then McCarty's office was over here.
About where the Tucson director, Amy,
About where Amy is, yeah. And then I was over here where the restrooms were.
Oh my.
And then back here, we had a little kitchen. And then we had a porch outside, and we stored files on the floor and on the kitchen and outside on the porch. We didn't have a filing system at all. There was nothing. I created one because they didn't know how to do it.
Burr, tell me, how is it that you came to work at McCarty and Chandler?
Well, I was getting ready to take the bar exam, and I got a phone call from Tom Chandler 2 days after Christmas saying, we need a lawyer and we hear you're looking for work. I didn't know I was looking for work, but I was. And I came down, had lunch, and they hired me, and I took the bar exam before I took finals. And then following that, I came here February 10, 1954. They paid me $200 a month. I got admitted March 27, 54, and they paid me $250 a month, and I wasn't worth either one of them. But I was glad to get it. It was a lot of money.
Burr, what kind of work were you doing?
Primarily, every lawyer in Tucson, you did everything. You did probates, divorce, criminal stuff. Primarily, the law firm was an insurance defense firm, and probably 85 to 90% of what we did was insurance defense. And back then, you never interim billed a file. You advanced all of the money. You never asked the insurance company to pay it up front. You paid the court reporters, you paid the experts, you paid everybody.
How did they handle the billing, Burr?
Their accounting system was a shoebox that was out by the receptionist, and if you remember to put a receipt in it, that was that. They had no system for what was going to happen every day. So I set up, we still use it, a calendar that showed it, because people would show up and the lady out front would say they're here for the deposition. Well, nobody knew they were here. We didn't have a court reporter. The court reporters were close, and you would do it. So I set up a system whereby everything went on a weekly schedule and got printed out.
Did you do depositions here at the office?
Primarily, we didn't have a conference room. You did them in the office.
And so some were done at the court's office?
Well, if you did a deposition while you were in trial, you would do it at the court reporter. He had a small office next to his judge's office, and you'd do it there. So then I set up an accounting system whereby when we spent money, Jones versus Smith, you recorded it. And at the end of the case, you sent the insurance company a bill. And it wasn't itemized. You didn't keep hours. You looked at it and you said you owe us X dollars.
No billable hours?
No billable hours. And probably, I'd guess, 9 to 12 times, give or take a few, I sent bills and the insurance company sent it back and said you didn't bill us enough. You got a good result. I'm going to throw this away, figure out a little bit more.
Well, you wouldn't hear about that today.
No, that's not going to happen. So the other thing that happened when I first started was they had files all over, and insurance companies can only close the file when they get the lawyer's bill. And so I stacked them up, and I had whoever last touched the file, it was Chandler or McCarty. And there were letters in there, some 6, 8 months old. Please send us a bill. So I stacked them up, got them to bill everybody, and brought in quite a bit of money the first 6 months I was there. And I think maybe they thought I was helping, whatever. But in January 1, I'd only been a lawyer 10 months. They made me a partner.
Okay,
so
McCarty, Chandler, and Udall.
Yeah, and I fought that. I still believe that 2 names is all you need. Snell and Wilmer, I think, is perfect. And I think, you got Jones, Smith, Black, Green, and whatever. The secretary answers the phone's going to say Jones Smith. They're not going to go through all the names. So, but anyway, it became McCarty, Chandler, and Udall.
Burr, do you remember how your firm grew?
Yeah. Chandler and Tuller were in law school together, and Tuller was appointed a judge, I think, in the late 40s, early 50s, and he didn't like it. The divorce part of it was driving him nuts. And McCarty had some health problems, and we needed a trial lawyer, and Tuller agreed to resign and come with us. Jim Richmond, who was in the same fraternity as Tom, was in the racetrack business, and he went to law school, and then Jim came with us. And so the firm became, what the hell was its name? Chandler, Tuller, Udall, and Richmond. And then I started fighting people about, we're not adding any more names. And 3 or 4 years ago, the people at my firm said, let's just call it the Udall Law Firm. So
Burr, what did you learn from the more experienced attorneys during your early years?
What I know is I was taught by my parents and by primarily Tom, but also McCarty, to be honest. Never, ever lie to anybody. And particularly, never lie to a judge. Judges' union is a lot tighter than you think it is, and if one judge thinks you're dishonest, he tells all the other judges. The other thing was to prepare, to get cases ready. As you well know from being a trial judge, the trial part's the easy part. The hard part is getting the case ready to walk and talk. And they taught me how to do it. And it's even back then, you could talk to anybody. Plaintiff's lawyers, defense lawyers. If you had a question about how to do something, you ask them. And people would call. And I've done that as long as I've been practicing law. I still get phone calls 3 or 4 a week from lawyers saying, what about this, what about that? And so the answer is they taught me how to be a good lawyer.
Burr, how has civility changed over the years?
Well, there's clearly been a change. When I started, and for many, many years, you never had personalities involved. I mean, you might not like somebody, but you didn't have it affect you because that was going to affect your client.
Focuses on the issues of the case.
Exactly. And, you know, they put in the SLACA rules whenever they put them in. You got to disclose things. We didn't have any such things, but we talked. Lawyers, we didn't. Somebody said a long time ago, pick up a phone, not the dictaphone. And we talked, and I would go to their office, they'd come to my office, they'd give me their file, I'd give them my file, and it wasn't trial by ambush. It wasn't at all. I don't honestly remember very few, if any, motions to compel before a judge. We worked them out.
Burr, what do you attribute the change, your view of the change of civility over time? To corporations, to the attorneys, what do you think's caused it?
I think it's more the lawyers, and some people feel, you know, they have to be this way to be successful. And what happens is if you're a jerk, the guy you're dealing with becomes a jerk also, and so it's not productive. It's not productive at all.
How did billable hours affect the practice?
It changed everything in the insurance defense work because all of a sudden the insurance companies, one of the biggest enemies was the defense lawyer, where before it was more we're a team, we're going to get it done. And then they started hiring auditors. Well, did you actually spend 2/10 of an hour talking this? You should have not 1/10. And so it became a little, you know, you were fighting with your client more about the bill than you should have been. And like I said years ago, you just looked at it and said, this is fair, and they thought it was fair. I mean, there was no big deal about that.
How did cell phones and technology change legal work?
Well, that changed everything as far as I'm concerned. I mean, I've owned 7 cell phones, and when my wife hands them to me, I hand them back to her. I still don't have a cell phone. We didn't have copying machines. We didn't have bar numbers. I can remember when all of a sudden you weren't a person, you were a number. And the state bar did that for whatever reason they had.
If you didn't have copy machines, how did you complete complaints?
You had a manual typewriter with carbon paper. And, you know, you could make 4 or 5 copies, but say you had a letter from the plaintiff's lawyer you wanted to send the insurance company. Some secretary had to type it again.
So you retyped medical records too. Did you ever make mistakes?
Well, it could from time to time. Court reporters didn't have machines. They were all pen writers. And like I said, I tell stories. And Tuller they would have on the table probably 20 pens. In case one ran out, they could grab one. Tuller's court reporter was a lawyer. And if Tuller ruled on an objection and he disagreed, he'd throw his pen up in the air. Which didn't seem to bother Tuller much, but it bothered the lawyers a lot.
How many judges were there back then?
When I started, we had 3 judges, Judge Johnson, Judge Garrett, and Judge Tuller. Everybody did everything. Judge Johnson did juvenile, Judge Tuller did probate. Other than that, whatever, I mean, 1, 2, 3, when you filed a complaint, you knew what judge you were going to get because it was based on the number. And some people tried to avoid a judge. Ed Morgan used to take 1 extra complaint with him, nothing, and if he was going to get Judge X, he'd file that complaint, and then the next one he got a judge he wanted to get. That was one way to do it. There was 1 JP, 1 U.S. District Court judge, 1 city court judge who was also the prosecutor. The city was we didn't have court commissioners, we didn't have magistrates, we didn't have judge pro tems. We didn't have mediations. We didn't have arbitrations.
You didn't do motions in limine?
No.
Depositions?
There was no such thing as a videotape deposition.
And you didn't even have an appeals court?
That's right. When I started, the courts of appeals, I want to say, came in the mid-70s. I always, when I go to Division II, I always look to see what year it was, but I'm not real sure. The Supreme, everything went directly to the Supreme Court. What else? What else didn't we have? Security. That's the, I mean, you didn't go through any metal detectors or nobody, you just went into the courthouse, into the courtroom.
Did you have a bankruptcy judge?
Not in Tucson. They had a bankruptcy judge in Phoenix that would come to Tucson. Judges didn't wear robes when I started.
How formal was the courtroom, Burr?
You could go to court, and I did, dressed like I am, with a golf shirt or just a regular old shirt, and nobody cared. And federal court, you had to have a coat and tie except July and August when it was hot, and then you only needed a tie and a white shirt. Judge Walsh was the only federal judge. He lived, I'll bore you with one more story. He lived on Broadway about 3 blocks east of Wilmot, right on the corner. He was in the phone book. He told me later he had a big-time drug dealer that got convicted, and he got a phone call at home at 3 o'clock in the morning from a guy who said, I understand you're going to sentence so-and-so next Friday, and we'll be in the courtroom, and if you don't do it right, we'll take care of it. And I said, what did you do? Did you call the marshal or the sheriff? Or he said, no, I just waited a couple of days and called the lawyers and moved the sentencing up a day, and there was no problem. But I mean, it was just a different world back then.
How did the clerk's office operate then, Burr?
The clerk's office closed at 5 o'clock, but back then, if you wanted to see a file, they let you go in. You'd walk in and say, you know, I want to look at whatever, you had the number, and they'd say it's right over there. And you did it, they had a little desk, and you'd sit and look at it. The clerk's office never closes, okay? So everybody in town knew the home address and the phone number of the clerk of the court, and you could show up at 2 in the morning, I did it, and ring the doorbell and file a pleading with her and pay the fee. And she learned early on to appoint one of her deputies as to be that person, so you knew who that person was. But we, you know, the courthouse was open Saturday till noon. But I think back then they used to set for trial, each judge, 20 cases every week. And if they got a case that ran too long, then you'd get through at 5 o'clock, everybody went out and had dinner. You came back at 6:30 and you'd quit at 10:30 at night. And I think the big problem with that was the clerk. I mean, you know, for the court to be open, you need a judge and a clerk. You don't need anybody else, but you need the clerk. And I think they were getting paid overtime, and the clerk's office was trying to get rid of that. So finally we got rid of it. One thing, and I think I mentioned, when I started, you could smoke. And the protocol, and they had ashtrays on, and you know, and the protocol, if the judge smoked, nobody lit up until he did, or she did. I mean, but if the judge didn't smoke, then you could smoke whenever you felt like.
Difference in respect and
yeah, right.
One of the things that he said that I believe was that now the plaintiff and defendant's tables are side by side, and apparently it wasn't always like that.
No. But when I started, the plaintiff's table was right by the court reporter, and the defense table was strictly behind it. You were looking at the plaintiff's back all the time, not looking sideways at where they were.
Tell me about the juries back then, Burr.
Jurors served for 3 months, and I remember trying a case a long time ago, and we were voir diring a jury, and the question, anybody knew me, and this guy put his hand up, and I thought, I don't know you. And the judge said, "How do you know Mr. Udall?" And he said, "I've sat on 4 of his juries."
This was almost
Yeah.
okay.
So they were there, and you kind of got to know them, you know. And it was, we had 12 people juries, took 9 to get a verdict. You couldn't get out of jury duty back then.
So once you were set, you were here, and you'd be there for 3 months, and
Yep.
you were on call, and if they needed a trial.
And if you know, it seems to me in this day and age, if you sit on a jury, that you're excused. They let you go. But back then, they may give you a few days off. If you sat on a 10-day jury, for instance, they'd give you, the clerk could just arbitrarily not call you for a week and let you get. But they were there, and you kind of got to know them.
It seems like it was a much smaller, more congenial legal community back then.
2 weeks before Christmas, there was, by that time, 4 judges. I went to the courthouse, and I took a bottle of whiskey for the judge, the secretary, the court reporter, and the clerk. And there was never a problem. It wasn't, I'm trying to bribe anybody, it's just saying thank you for all the good things you've done. Judge Malloy went on the bench and accused me of trying to bribe him, so we quit doing it.
Yeah, and ethical rules came along.
Well, probably, but we weren't, I mean, ethical rules were there, but, you know,
This was just a courtesy, and
Yeah.
it wasn't looked at as anything that was...
I mean, my uncle was the judge in Safford. I tried probably 5 cases with him as the judge. Nobody thought anything about it. He didn't, I didn't, the plaintiff's lawyer didn't, because everybody knew if it was close, he was going to rule against me. That's the way it worked. But the legal secretaries used to have a Christmas party, and it was a hell of a party.
So people get together and...
Oh yeah, all the judges, all the lawyers, and it was congenial.
Why do you think things changed?
I think the billable hour has something to do with it, Judge. I think, and you know, I know some plaintiffs' lawyers who say, I'm not going to talk to them because all I'm doing is running up their bill. Yeah. And we never, as long as I've been practicing law, even when the billable hour, we've never hired anybody who said, you have to bill X hours. We do good work. And that's my theory is if you do good work, the client will keep you.
Do you miss those days, Burr?
I do miss it. I miss it greatly because too often now, when the trial's over with, the loser says to the other side, I'm going to get even with you. Back then, we shook hands, went and had a drink, and you went on to the next case. I might as well tell a couple of stories as long as we have nothing better to do. One of my, Chandler and Hal Warnock, who was a lawyer at the Bilby firm, were trying a case in Safford where it is a crossing case. They sued the car driver and the railroad. The railroad wouldn't offer any money, and they picked a jury. Nobody knew anybody. When they got done about 4 o'clock, and every juror walked down and kissed the plaintiff goodnight. And everybody moved for a mistrial.
This was in Safford?
In Safford. And Uncle Jess was the judge, and Uncle Jess said, you don't understand small towns. This lady hadn't been out of the house since the accident. She hadn't been able to go to church. She hadn't been teaching. They're just glad to see her. That motion's denied. So the lawyers go back to the motel and they get a bottle and they're having a couple of drinks, and Warnock says to Chandler, what are we going to do? And Tom said, I don't know what you're going to do, but I'm going to kiss her good morning.
little different.
Yeah, it was a little different before. And my other favorite Tom Chandler story, and Tom's trying a case in Division I, which the old courthouse we talked about that's still there. And that courtroom, the entrance is on the side, and you're looking right at the jury as you walk in. The jury's in the box. It's a slip and fall case. Tom had filed a motion, or argued a motion for direct verdict on the grounds they hadn't proved there was anything on the floor that caused the guy to fall. And the 2 lawyers are standing in the door with the jury in the box. blah, 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 and he's here. And they come in, they say to the judge, we want to reopen. He said, okay. And so they put the client back on the stand and said, do you remember if there's anything on the floor? He said, yeah, I told you I was unconscious, but I remember waking up and there was Kate Johnson's wax on the floor. That's what caused me to fall. And they said to Chandler, you may cross-examine. And Tom said, when did you dream that story up? And he said, last night I woke up and remembered it. And he said, isn't it true? Not over 4 minutes ago, standing at that doorway, your lawyers told you if you didn't testify, the judge was going to throw you out of court. And the lawyer got up and said, we object. It appears Mr. Chandler has been eavesdropping. And the jury roared. Then he said, we object on the grounds it's a confidential communication. And they roared again. And then he said, we object on the grounds the record should show we never said any such thing. And the judge directed a verdict. That was the end of the case.